Yes, I am grateful to you all to watch our show regularly. As you know, in this module, we are going to discuss with you the legal compliant digital architect. We are all aware that modern era is characterized by data and its protection. Everybody is worried how data should be protected, whether it is an individual, any organization, any nation, or globe at large. Data is the real asset. Everybody is challenged that his or her data is whether in the safe hand or not. Further, friends, right to privacy becomes very significant, and particularly in Indian scenario, the Honorable Supreme Court of India in K.S. Puttaswamy, a retired High Court judge versus Union of India in 2017 has declared the right to privacy as fundamental right, being the integral part of Article 21 of the Indian Constitution. And you will surprise that in the same writ, another judgment was also pronounced by Honorable Supreme Court of India in 2018, and that is called Aadhaar case. So these twin cases, which have been originated from the same writ, so these twin judgments are very critical and important. How globally India became the first country to recognize the right to privacy as fundamental right. That's very, very significant. But it was a very critical scenario how data should be protected, how privacy should be protected. So in 2018, GDPR was introduced in European Union, and its Article 25 has brought very important segment, and that is called legality by design. And that's the most important part. We will be discussing in some time later about what is legality by design. But in nutshell, I must say that now it is the era of integration of law with science, science and technology. Now, technology cannot work in silo. It has to be integrated with law. And not only integration in patchwork type, it has to be integrated right from the inception of any technology or any planning of technology right from the beginning. Ab initio integration of law with technology is the future of technology in the real term, so that there should be no violation of data protection. So having said that, let's start, friends. Today we are going to discuss how to ensure legally compliant digital architect, which is a global challenge, and definitely in Indian context, we will also reflect today on Information Technology Act, that is IT Act 2000, and DPDP Act of 2023. So this will be a kind of series. In next talk also, I will discuss with you few more topics, but they are interconnecting things. So before we begin, I'll just give you some idea that in 1984, the Federal Bureau of Investigation in United States has first used computer evidence. That was the first year. So you can say that digital evidence had its origin in 1984 onwards. Then in 1991, a new term called computer forensics was introduced, and India, as I told earlier, the Information Technology Act was introduced in 2000, wherein the cybercrime were kept, but cybercrime in those days were very limited in scope. However, now there is a need to have more robust, recipe of cybercrime in the IT Act. We will discuss sometime in the next series. So, in cyber law in general, friends, if we see what are the challenges actually, so digital evidence are invisible, they are fragile in nature, there are no geographical boundary like in conventional crime. Suppose any conventional crime like murder, rape, burglary, dacoity, theft, or any such crime if happen, it has some physical boundary. But in digital space, it is invisible, it is fragile and boundaryless. So boundaries have been melted. However, the laws are limited to boundaries. So this is a complicated scenario. Then there is no international legal regime. The United Nations conventions and others, they are only advisory. They have no enforceability per se. Then these technologies, they are ever growing. They are evolving. Very rapid change. But law cannot change that fast. So the lag between the technological advancement and legal evolution, there is a vast gap. And criminals take advantage of this void. There is a lack in growth of digital technology and law, as I mentioned already. Cyber laws are also called IT laws, information technology. Why? Because information gets flow. So basically in cyberspace, as I told, that is characterized by interconnects, internet. So when you talk about cyber world, that means there are some interlinkages or some flow of information. India has introduced the Information Technology Act in 2000, as I already mentioned. Then before we begin, let's understand some important concept. This is a digital space. We can divide it into three: the surface web, the deep web, and the dark web. Surface web means then like Google. You write something and you get some pop-up sites and you can directly enter without any kind of security features. You need not to have any OTP or any password or anything. Straight you can open. So that is called open web or surface web. Then it is deep web. Deep web is like your networking in internet or your net banking or any like your Gmail or any such thing where you need to have some OTP base or some password. So that is called the middle or the deep web. Then there is dark web, which is run under very secret manner. It has lot of encryption, like onion. Suppose the Tor, we will talk about what is Tor. Tor is basically like onion. Onion has several layers. So layer by layer, if you go deep and deep, then you have the encrypted version of the data packet. And that is why it is difficult to reach what exactly was the message. So in Tor or a dark web, there may be flow of good information, but most of the time there are secret information, flow of secret information. And mostly the criminals or people who want to avoid the law, they use dark web. So dark web becomes to some extent symbol of criminal web. Although with this tag that this space is also used for good work or for better, you can say, information in the right perspective as well. Friends, before I start, I will tell you a very simple way to understand the digital communication. So, I will give you a kind of brief understanding how we were sending our information through letter by physical post office. So similar type of things are there. What we were doing in our traditional post office, we were writing some message, some letter, some information on piece of paper. There may be some inland papers, postcard or something like that. Likewise, we are writing now on digital wall. So the message is there, the medium is different. That time it was physical, now it is digital. So that is a content, and that is called packet. Here it is also called data packet. Then we need to send it from one place to another place. Likewise, in digital world, you are sending message from one place to another place. The medium earlier was the post office. Here also we have POP, post office protocol, in digital world also, right? Now you see how the address were written. Earlier the address were written, suppose a letter is to be sent to Dr. G.K. Goswami, the name of the receiver, Dr. G.K. Goswami. The another is my house name, then mohalla or street, then post office, then district, then state. So if we see in digital world also, there are two type of address. One is called logical address and another is called physical address. What does it mean? Go back to the earlier letter. We were writing from where the postman will see. It will see from the state, then district, then post office, then mohalla or street. So this is called logical address, because you cannot jump directly to district, you cannot jump directly to village or mohalla or street. So you have a logical way of moving from state to district to mohalla and then the house. That is logical address. And the name, the person to whom it has to be delivered, it is called physical address. In digital world it is called MAC, medium access control. And I have already told POP, post office protocol. Now you need to have some, how you will send the letter. You were being sending by either train or by bus or by air. So there are two ways. One is the road transport, another is the air transport. Here again, if you have cable system, it is your direct like a road. Then if you are sending by wireless system or by internet, that is wireless, or by air you can say. Then comes the bandwidth. Bandwidth means like you are sending the traffic of information, right? So on road, if you see, there are so many buses, so many cars, so many cycle, motorcycle, two-wheelers and all. So the traffic can be smooth if there is ample space on the road. If you need more, you need to have widening of the road. So widening of the road, here is your bandwidth. That how much space you are getting for the flow of information. That is your bandwidth. If you want more traffic to move, then you have to have higher bandwidth of your internet. Suppose there is a limit of expansion of road. Likewise, in digital world also, you cannot expand for infinite. Then what you do on road? Then you have some restriction of the vehicle. What you do? Generally the heavy load trucks, buses, they are being stopped at the peak hours. Likewise, in digital world, you stop the heavy packets like videos or the photographs, the heavy loaded packet of information. So that like road, you are just copying what is happening in the physical world. Then comes the router, by generally called router, but basically it is router, R-O-U-T-E-R, router. Router means the device which finds the route, and it is considered it like a crossing where a traffic man is standing. What is the role of traffic man? It controls the traffic. So router controls the traffic. Suppose there is a heavy congestion on particular road. What the traffic man will do? They will divert. Likewise, the router does that if there is a congestion on any particular lane, then they divert the traffic. Like in the physical world, you may have some dedicated lane for VIP or some important, work, some emergency dealing. So in the digital space also, you may have some committed lane for data transfer. Then comes the switch and hub. So hub is considered to be the full paradigm. I will tell you why. Suppose there is a postman, and postman is completely new to the area. He does not know who is who. So what he will do, suppose there are 100 persons in a particular place. He does not who is who. What he will do, he will go door to door asking whether this letter belongs to you, whether this letter belongs to you. Likewise, he will go door to door. It will spend lot of time. It will unnecessarily announce that such information is flowing from X place to Y place. So it will be a nonsensical approach. Rather than that, what switch does, switch exactly transfer the data to the receiver directly without wasting time and without announcing to others that such type of information is flowing, right? Then comes the bridge. Bridge is basically connector between the 2 points. So these are certain points where I hope you understand that in the digital world, the transfer of packet, transfer of information is almost identical what we were doing in physical world through our post office since ages. Now, the IP address, most of the things I have already mentioned, the logical address and the physical address. Internet protocol address, I have told. IP means Internet Protocol. Identity of device on a network. So, what IP address tell you? It tell you that what is the particular device where the information has begin with and where it will landing. So, it provide the address of the device. Then it provides geographical location of the device where that device is located. It enables device to communicate with each other over internet. It helps to deliver data to correct destination, right? So the address, like on your letter, it is IP address which actually deliver the information to the right receiver. The type of IP address, again, see the physical world. Suppose a person usually stays at his home, that is static address. Suppose a person is moving and he want to get the information or letter, then it is called dynamic address in terms of digital world. So change periodically, often assigned by dynamic host server protocol, DHCP, server which automatically assign IP address. That is called dynamic IP address. Dynamic IP address means the device is not static, it is moving. Then the router, or called router, it is basically the route finder. Router is like a traffic manager, traffic cop on road that decide which route each data packet should take to reach its destination quickly and safely. So like you want to move on road safe and quick. Likewise, your data move on your bandwidth safe and quick is the expectation. Then it checks the destination IP address so that it should reach to the right destination. Suppose a traffic man is standing and he misguide you. Suppose you are going to X place and he says, no, this is the right thing, and you will land to Y place. So will it be correct? So router is basically to direct the data packet to reach to the right receiving end. then consult its route table like a GPS. So who will guide the router? GPS may be very good asset. Then it sends the data packet to next network hop or destination server. The packet forwarding, it determines the best path. As I told that the traffic cop will tell you which is the right path where you will be safe and save your time. Safe and saving the time. These are the two things. Then firewall capability. Suppose there are some threat on road. So you have to have some kind of safety features, and here in digital world we have firewalls, VPN and many more such zero trust cyber security landscape. So these are certain important areas. Then Wi-Fi distribution, it send and receive data wirelessly via radio wave, I have already told you. Then router is a backbone of the data communication. It connects with other network, secure data communication. I have already mentioned you in little more detail. Then Tor, T-O-R, the onion router. So when router is like onion, then it is Tor. Tor basically to conceal the identity of the receiver as well as the sender. So what it does, it has various layers how data get protected by way of encryption, and then it is difficult to find the IP address of the sender and receiver both. So that is why Tor actually work in dark web to conceal the identity of sender as well as receiver of the packet of data. So it connects user's location and usage from surveillance. Basically it bypass surveillance devices, and it works like message encrypted multiple times, like onion I said, that you plug out one leaf, then another leaf, then another leaf, then another leaf. So you never know how many leaves are there. Encrypted message is randomly selected for Tor relay via entry node, middle relay and exit node. Each node only knows the previous and next hop, not the original or destination. It is something like message is passing from A to B, B to C, C to D, and likewise. So only two neighbors, like say for example A to Z. So B knows only C, F knows only next, so they don't know the entire chain, and that is the beauty of Tor. But for the law enforcement agency it becomes very difficult because lot of nefarious activity do happen based on Tor. You can say the router may be Tor. Then how Tor and dark web are interconnected, as I already mentioned. Dark web means websites that are not indexed by search engine and accessible only via Tor. So in dark web, the surveillance agencies, they actually feel handicapped because of various encryption methodologies. It conceals users' location and usage from surveillance. Tor working message encrypted, I have already mentioned these things. Now the virtual private network, it is again the alternative, and I must say it is better than firewall for the safety of the data transfer. VPN is a secure tunnel between user device and the internet to protect data, preserve privacy and bypass geographical restrictions. So this is yet another advanced technology to bypass the location and the identity of transfer of data. VPN encrypts internet communication and route it through remote server, hiding IP address, protect data packet from surveillance, hackers and data theft. So that is a big challenge. VPN basically is a big challenge for law enforcement agency like police and other organizations. How VPN function? User connect to VPN on their device. VPN encrypt all outgoing traffic. Then data is sent to VPN server in another location. VPN server send data packet to destination, and then it receive the VPN server's IP and not the sender's IP. So there are a lot of challenge for police officers. I have seen in CBI and other agencies that how difficult to crack the data, although nowadays some advancement has done, but still for the local police and others, cracking the VPN related message transfer becomes still a mystery. How VPN may be abused, cybercrime by hiding identity. See, any criminal for that matter, what it is first means wish. He wants that he should not be identified. He should always be hidden by the police or any law enforcement, and so is with the VPN. Spreading illegal content, then rumor mongering, bypass law enforcement tracking and all. So VPN is used, or you can say misused or abused by the law avoiding outfits and all. Then global response to VPN. In India, VPN is legal with regulation. The regulation is basically the certain regulation 2022. In USA it is legal, but there is no specific login law, but subject to federal subpoenas. In Germany again it is legal, subject to GDPR. Russia it is restricted, China it is restricted. So VPN are restricted in country like Korea, China, Russia and all. So there it is a punishable offense. Then alternative of VPN, these are another method of bypassing the surveillance. There may be proxy servers, Tor I mentioned already, zero trust network access, then SSH tunneling, DNS, secure access service edge, SAS. This is a kind of comparison that what kind of server network are being secured in different ways. That in VPN it is encrypted, it is masking of IP, it provides anonymity to moderate extent, it is easy to use, and it is general users they use VPN. The proxy server, Tor, Smart DNS, ZNTA, SAS. So encryption actually increase in ZNTA. So there are advanced version. More and more encryption means that you have better facility to bypass surveillance. So encryption actually create more trouble for law enforcement agency to crack the route how the data has been transferred from one end to another. Then anonymity, again, anonymity is very high in Tor still. Although ZNTA and SAS are more advanced technology, but anonymity of sender and receiver is still higher in Tor. Then speed is higher in Smart DNS, that is why it is called Smart DNS. Ease of use, they are moderate, although ZNTA and SAS they are complex. However, they are being used for different purposes. As I mentioned in the suitability, that how different technology can be used by different users. Now the safe harbor protection. This is yet another important area, my dear friends. Earlier also in our short video I have discussed it in 2 to 3 minute space. This is why this safe harbor. That you might be recollecting what we have discussed earlier in our short video, two terminology which is very frequently used in our DPDP Act as well as another set of rules for data protection including GDPR. One terminology is called data principal, the owner of the data. The another is called data fiduciary. So data fiduciary means who is actually is the fiduciary means those who have the fiduciary relationship with the data owner. I give you example. Suppose I am interested to buy VSNL or any service provider for my mobile service. I provide the data before I get the SIM. So data fiduciary is VSNL or the agency to which I have submitted my data, and I became the data principal. I am the owner. Okay. So, or say for example, we have an account on Facebook or maybe LinkedIn or any social media platform. We post our information over there. Suppose a user posts something which is very objectionable. So who will be liable? Whether the platform or the who have posted it. So there is a safe harbor protection to the service provider. Say for example Facebook. If a person who is a user of Facebook post some objectionable post over there, maybe photograph or anything. So until and unless the Facebook is given some kind of legal protection, and the liability if suppose imposed on Facebook, then how these platforms will work. So the liability would be who has posted it. But the service provider or the social media platform will get this benefit of safe harbor protection only if they fulfill certain conditions. What are those conditions? We will discuss. So it is an integral part of cyber legal architecture. It provides protection from liability for internet intermediary like search engine, like Facebook, your cloud service for content posted by third party if they follow certain conditions. What are those conditions? Intermediary play neutral. They should not become party for posting or protecting or erasing or something like to support the person who is third party who has posted some objectionable thing. He should be neutral. Then in case any information is shared by law enforcement agency with the platform, they should promptly act and must remove unlawful content once notified. That is called take down notice. Take down means taken away. Safe harbor, if we see in Indian context, so our section 79 of IT Act has introduced safe harbor protection via amendment 2008. The condition for having safe harbor protection, intermediary not initiated or modify the transmission. That means it is the third party who is responsible. So the platform should be neutral, then comply with due diligence as mentioned under RT rules to 2021 and act within 36 hours to take down the content after receiving notice from the authority. So 36 hours is the maximum time after receiving the information to remove that content. That means to take down that content from the platform. So then they will get this protection. Otherwise, they will also be held liable like third party. So safe harbor protection, let's see in other jurisdiction what is the scenario. United States under section 220 of communication deficiency. European Union, already it has the e-commerce directive under 2031 EC. Now it is replaced by Digital Service Act 2022. In United Kingdom, it also follows model EU model till Brexit, and now it has Online Safety Act 2023. In Canada also they have regulatory guidelines. Australia they have Copyright Act and Online Safety Act 2023. So I think if we see, although we will talk about how the evolution part of Digital Protection Act, it starts since last 1973, but in my opinion, EU is the landscape where in 2018 the proper architect of data protection has been laid down and it has become like the benchmark for construing the law on data protection globally. Now let us see electronic signature. Electronic signature and digital signature. These are the two things. We will see how they are different. Electronic signature in IT Act of India is defined under section 1 subsection section 2 subsection 1 TA, and it is basically, it is defined, electronic signature means authentication of any electronic record by a subscriber by means of electronic technique specified in second schedule and include digital signature. So electronic signature include digital signature. Electronic signature is a wider term and digital signature is subset of electronic signature. Encryption technology is being used. You might have heard in the government department and many more such type of responsibility once you wear that I have digital signature certificate, DSC, right? That is issued by certifying agency. They may be private, they may be government. They authenticate the identity of a person. Signature does not mean only merely signature. Signature means identity of an individual. Like we have our identity card, maybe our Aadhaar card, something. So for our signature, this DSC is our identity. Then integrity. It ensures integrity. It is not something else has did it. Then no repudiation. No repudiation means you cannot take away once you have signed the document or once you have put DSC on paper, on record. The type may be DSC, PKI, public key, infrastructure, click to sign. So these are various variants of the electronic signature. Then these are recognized under section 3 of IT Act. 3A of IT Act says it validates other form of electronic signature and they are uniquely linked to signer, capable of identifying the signer. As I said that it is identification of the signer. It creates under signer's sole control, linked to the document, and they are reliable. They are used in contracts, bank forms, tax returns, e-governance. But mind it, that last line is very important. Electronic signature cannot be used for negotiable instrument. You cannot use it on your bank check. Negotiable instrument means check or hundi or something. Power of attorney cannot be signed. It has to be done in physical format. Trust deed, will or testament, contract for sale or conveyance of immovable property. So like you are transferring the property, you have to go to the registrar office of the registration of land and records. So mind that e-signature cannot be used in any kind of means bank instrument, your deed, your trust, your transfer of immovable or movable property and all. Then electronic signature legality. The usage, they are used in contracts, bank form, tax returns, e-governance service. I have already mentioned they cannot be used for negotiable instrument. The section 66 of Bharatiya Sakshya Adhiniyam has under section 66 proof as to electronic signature. Except secure electronic signature, such signature must be proved. And these are other sections where certain presumptions regarding electronic signature are being. Now, electronic versus digital. What is the difference between electronic and digital? As far as definition is concerned, electronic signature, any electronic method used to indicate approval or consent on a document. In electronic signature, we use simple technology. You can type the name, scan the image, click to sign, biometric. So biometric is also kind of digital signature, electronic signature, sorry. But digital signature are more authenticated. Electronic signature, suppose you have given your face recognition tool or something, or sometime you put your thumb, right, biometric. So these are called electronic signature. But digital signature, DSC, as I said, that digital signature certificate, that is more authenticated, and these are the legal recognition. Electronic signature are being recognized under section 3A of IT Act. However, digital signature are being recognized in section 3. The electronic signature are less secured. However, digital signature are highly secured. Electronic signature not always controlled by the government authority, but digital signature are highly controlled. Even if the the authority which actually certify, the CA, certifying authority, they may be in the private sector, but they have to fulfill certain conditions. Electronic versus digital. Another aspect, the integrity verification. They are not usually verified, but in digital signature they ask you a lot of your verification documents so that your genuineness. Those who maintain DSC, they have more document to submit before they get DSC. Certifying authority not mandatory always, but in digital signature either it is being issued by some certified agency like NIC, CFI and all. Then revocability, electronic signature can be repudiated, but digital signature cannot. It has final validity. Electronic signature, they may be used in court, but they do not have very high evidentiary value, but the digital signature has very high evidentiary value. The admissibility quotient is high because it is covered under 65B certification in the previous Indian Evidence Act and now under section 63 of Bharatiya Sakshya Adhiniyam. Then cost and acceptability. Electronic signature are low cost and digital signature needs some higher cost to buy. Examples: typed name, clicking, I agree, drawing signature. Right? Sometimes you must see that we go on some platform, they just give you a stick and just we sign. That is actually electronic evidence. But in digital, you need not to do any mechanical or the physical signature or something like that. Now let us enter into the domain of cybercrime. Cybercrime, friends, we have two things here. One is crime, another is cyberspace. And where there is a crime, there is an injury. Injury may be physical, may be personal, may be mental, right? May be financial. But there has to be kind of injury. Crime needs two basic things. Mens rea, that means your guilty mind, and actus reus, some act to fulfill that desire of guilty mind. While cyberspace may be used as target or medium to commit the particular crime in the cyberspace. Now the salient feature of IT Act, the Information Technology Act has 13 chapters. I think there are 12 chapters. Sections were earlier 94. However, 91 to 94 sections have been repealed. So now practically speaking there are 90 sections functional. The Schedule 2, only 3rd and 4th have been repealed. The entire act came into force on 17th October 2000. The salient features are multiple: legal recognition of electronic records, electronic/digital signature, electronic contracts and digital transactions. Then e-governance and e-filing, data protection and privacy was also recognized. Compensation and education mechanism were very much there, and earlier it was the fine up to 5 crore. However, in DPDP Act, the fine is to the tune of rupees 250 crore. The cybercrime, the different variety, as I said, they are hacking under section 43, identity theft, which is very common, under section 66, and particularly theft under section 66C, phishing under section 66D, publishing obscene material online, that is 67 section of IT Act, cyber stalking and online harassment, sending obscene message through communication and all, right? Role of CERT in CERT basically Indian Computer Emergency Response Team. So CERT, Computer Emergency Response Team dash IN means Indian. It has handled the cyber incident. This is a nodal agency actually since beginning almost. Issue security alerts and advisories. Promote best practices for cyber security. The power of interception and monitoring is under section 69. The liability of intermediary, very important, which has been elaborated under the DPDP Act. Particularly the liability of intermediary lies from section 4 to 10 of DPDP Act, and it provides safe harbor protection, as I mentioned already, that the service provider should not be harassed until unless they have some connivance with the third party to publish any illegal material. They are punished only if they act as facilitator and not neutral. If they take down unlawful content within 36 hours, as I told, they will not be punished. They must follow due diligence guideline under IT Rule 2021. IT Amendment Act 2008 is very important, and we will talk about that. Few salient features of Amendment 2008. The legal recognition of electronic signature. There are enhanced cyber security provisions, particularly section 66A to 66F, they were being introduced. Cyber terrorism, for example, 66F. Identity theft, 66C. Interestingly, 66A was struck down when in Shiv Sena, the chief, Sri Bal Thackeray ji, was dead. He passed away, and Shiv Sena declared Bandh in his memory, and then two girls were just chatting on cyberspace on Facebook probably, and write that what this nonsense type of thing they wrote, and then police took action against them, and ultimately they were being arrested. A case was slapped on them, both the girls. Ultimately matter went to Honorable Supreme Court of India, and section 66 was struck down. So that is why the section 66A was repealed. New cyber crime have been recognized under Amendment Act 2008: data theft, hacking, phishing, spamming, publishing sexually explicit content, then child pornography. So always remember section 66 and 66(7). These are very important for various type of cyber crime. Data protection and privacy is being incorporated under the Amendment Act 2008, particularly section 72A, the penal provision it has. Now let us see the guidelines, the rules, particularly IT Rules 2021. They have been notified by Government of India on February 25 in 2021. Then it supersedes the IT Rules 2011, and it has particularly 3 parts, and the different things those who are interested can see. I will share these slides on our platform. The Rules 2021 has certain objective, mainly strengthening user-friendly safety and grievance redressal mechanism. Then it prevents misuse of social media and digital platform, ensure accountability and transparency. It empowers the user against harmful content, and introduce soft touch regulatory framework for digital news and OTT. Due diligence. So safe harbor protection and due diligence, they are the two sides of the same coin. Under Rules 2021 Part 2, due diligence for all intermediary. If they follow due diligence, then only they enjoy the right of safe harbor protection. To publish term of use privacy policy and rules prohibiting unlawful content, they must remove or disable access to such objectionable content within 36 hours after reporting by the law enforcement agency, and preserve information for 180 days for investigation purpose. It provides information to government agency for investigation and appoint a grievance officer to resolve complaints within 15 days. So these are certain important addition by Rule 2021. Further, due diligence has additional due diligence for significant social media intermediary. These are the platform which over 50 lakh registered user. So there are two type of intermediary. There may be less than 50 lakhs users or more than 50 lakh user. So their due diligence has higher standard in case of the bigger size of the platform like Facebook and others. So they have to appoint chief complaint officer. They have nodal contact person 24/7 round the clock. They must have grievance officer and they should reside in the country. It is not as if the office of Google may be in United States, but they have to have grievance officer in the country concerned. The traceability of first originator must publish monthly complaint report of complaints. The content labeling such sexually explicit or harmful material, age, rating, etc. So there, when you use Facebook, they ask you so many information, and that is because of to comply the rules and regulations of the jurisdiction they are providing the service. The code of ethics also very, very important under part 3 of the Rule 2021. The digital news website, OTT platform, the guidelines are very clear. They have to follow the Press Council of India cable and TV guidelines. The 3-tier grievance redressal mechanism under they have 3 levels. Then the challenges, let's see what are the major challenges. Alleged infringement of fundamental right. Generally, many people say that they actually abridge various fundamental rights because of IT rule, particularly for surveillance of the information in the name of the means public safety, national security and all. Then imposing content regulation without parliamentary approval. Traceability clause is considered to be threat to end-to-end encryption. So these are general challenges, or you can say the flip side of this, but it has its reason why these type of restrictions have been imposed, right? The IT Amendment Rule 2022 and 2023, it empowered the Grievance Appellate Committee. It introduced fact check mechanism by the Press Information Bureau. Nowadays you might be knowing that fact check, if there is any information, fact check must be applied before publishing further. So that has been introduced by IT Amendment Rule 2022, the fact check. Then it is standard obligation on gaming intermediary and online betting platform. Online betting, gambling, this becomes very, very problematic for the society. A lot of people becomes bankrupt. Considering that into account, the government has introduced these strengthening obligation on these points. So if we see the DPDP Act and IT Act, a comparison for nature of entity regulation. In IT Act it was 79. However, DPDP Act grant broad immunity to intermediary, right? And it has been actually from section 25 of GDPR, that is the origin. Then liability shield, it was conditional, but there is no explicit immunity imposed to data protection obligation. Due diligence, the due diligence is much higher standard in DPDP Act compared to IT Act of section 79. Then grievance mechanism under section 79 basically through grievance officer, but grievance redressal mechanism for data protection is also there. The user's right, or here we call it data principle in DPDP Act. Then enforcement agency under IT Act was meaty and certain, but in DPDP Act it is Data Protection Board, DPB, which has to be still, which yet to be established. So meaty and cert are the implementing or enforcement agency. You might be aware of these two agencies very prominently. Then dual compliance requirement, very important clause. Understand that? Section 79. I think Section 79 for the regulation purpose is very, very important to understand, and I suggest to read it in more detail because I have to cover the entire gambit, so that is why I could not emphasize specifically on this section, but still let's see what it is. It focuses on content liability and intermediary protection. The DPDP Act focuses on protection of data right, ensuring fiduciary accountability. So data fiduciary must be accountable. They should not be freelancer, whatever somebody is posting on the wall. It cannot be like that. You have to, because you are the platform where the information is flowing. So what kind of information is flowing? It should not be detrimental. It should not be illegal. Indian legal system requires dual compliance of Section 79 of the IT Act and DPDP Act for the purpose of data protection in terms of ensuring lawful processing of personal data, under consent and transparency of use of data, timely publication of data breach, that is 36 hours as we mentioned, retention and deletion of data policy, so data right to data erasure and all. Failure of observance of above general condition may impose penalty under DPDP Act. As I mentioned, under Section 79 or under IT Act it was 5 crore, but under DPDP Act it is to the tune of rupees 250 crore for first violation of data. The certain guidelines, it highlights the certain guidelines in 2022. The title was Direction under Section 70B of IT Act, issued on 28 April. It is applicable to service provider, data center, government organization, intermediary and body corporates. The certain guidelines, actually the reportable incident include unauthorized access. If suppose somebody has unauthorized access to your website or your content on any platform, then these guidelines approve. The data breaches, ransomware, denial of service, identity theft. So most of the problem a user is facing, they have been considered under certain guidelines empathetically. All systems must synchronize their system clock with network time protocol. The retention period is 180 days, we have already mentioned. The data localization must be stored within Indian jurisdiction. It is not as if the data is stored somewhere else. The mandatory registration for VPN provider, because VPN, as I said, is the threat to identify the IP location. So a lot of criminals and other nefarious activity may do happen. That is why the VPN service provider has to have a registration. Actually, they should have maintained the documents to whom they provide VPN subscriptions. Then the criticism against these guidelines, it says that it hurt data privacy. They are extraterritorial jurisdiction. They help business continuity, and also there are certain interpretational ambiguity in these guidelines. Now we are coming to the conclusion part. So in this slide, I have actually made comparison that in country like India, reporting is mandatory within 6 hours in case of data breach. Then log retention for investigation and all to share, it is 180 days, and notable laws are DPDP Act, IT Act, certain guidelines and all. In USA, the reporting is mandatory, but in different states it varies from one to another state. Then log retention is again because it is sectorial law. Then notable laws are HIPAA. HIPAA is basically for health care sector. Then European Union, the reporting is within 72 hours, limited by purpose, GDPR, NIS directives. Singapore, yes, reporting is mandatory by the service provider or by the data fiduciary. Then there is a reasonable period, not very much specified, Cyber Security Act. In Australia, it is for critical sector only. The reporting is only for critical sector. Then log retention is required, and it is dealt with Security of Critical Infrastructure Act. And with this, in around 1 hour, we are able to discuss this very critical and very important area where we could understand today the nuances of laws in India, particularly the IT Act 2000, DPDP Act, and a bird's eye view of data protection laws and privacy, sector, how they are intertwined and how data protection is important in order to secure the digital world. So data security and data protection are, friends, two sides of the same coin. So we will continue with more awareness to upgrade your understanding, to empower you in the digital space so that you should be safe, you should not breach the law, and you should be a law-abiding person, law-abiding organization, law-abiding citizen. With this, thank you very much once again. Share our website, our YouTube channel, subscribe it, and give us your advice, your observation, your comment in the chat box. Namaskar, Dhanyavad, Jai Hind.